Yes, it's your once.
Then they tell you to pay. Okay, I can take it.
So then you pay.
But then you can
The travel inside.
Hey. Then you them to them. You can't. But now the other thing they don't like. Tomorrow before Yes, yes, there was one. Thank you. Haikuwa nayo, mimi ndio nilikuwa. Haikuwa nayo. Wakili wa nini? Anakuja kusema nini? But what? Why are they entertaining those things? Anakuanga mjini. Mumanyi akurada.
Who has the access? The other thing is that when who has the so that the person who the avoid the access, it is supposed to get up those elections.
Yes, sir. Yes. We already gave instructions. Yes, I understand.
All of them. We must.
We must. I'll need you tomorrow.
So we must. Some of them. Was after every case. Evidence came that was massively but that's because of when you were just at the back of now. When there is evidence involved, and the court accepts, and the court accepts, they mentioned that I'm posting my server this server is the one that is Because that is where I was reading. So some of the elements we must have the sample that within the reach of the courts, within the reach of the Constitution. They say they have so that it means there is an interface between the IPC and the trial persons. But again, but if you go to the Convention Act, there is no that link. That link is not a link. So we must create the link between the IPC and the office of the registrar of persons. We must synchronize it. They never do it. Number two, we also need to say, like the way we are saying we are going to review our constitution every 5 years or 10 years or 8 years. Even the register must be politically driven. As we review the boundaries, we also review the register politically. So that we are not then saying, whenever we need to review it, we must synchronize the review of the register, the review of the boundaries. How we do it. So they have to be registered again in that. Why can't you have to fresh? The register. Yes. No, not anywhere. We are refreshing as we refresh the boundaries. One time, that's all when you want time. Never one time. So, we have to must is that they are going to say now the this was the reason on the justification for it. Which is arising from the population census. So that the constituency can also clear also near the limits we are refusing. So if we don't refuse the material at that time, it will affect the question of the petition. Because there will be people, yes, there will be people who are not represented. Yes, there is an MP there, like what is happening. But in Iloilo, there are people who are not represented. Because they are beyond the population, so Iloilo, although we have an MP, kuna watu ambao hawana elimu. So to avoid that, presidential elections will happen in each and every constituency. So, and the contemplated constituency has undergone the due process of qualification and qualification. So if you do not limit this qualification, does it conform to the template?
Anaendelea yuko hapa.
It doesn't. It doesn't happen. And that's the thing.
Na nishakwambia
First of all, I wish to more sincerely apologize. This was 1 hour late. So my sincere apologies for that. So we can get this warrant. So let me just call out Plea 382 of 2025. Jayne Kihara.
Wanjiro is for the brief Mother Karua. She's a zero starting brief for Mother Karua. Manzo is for the brief for Alonso Misioka. Daniel Amalemba is for the accused.
Present, Your Honor.
Associate Kihara has appeared in
Good morning, everyone. For the state, my name is Mo. The police is Sonia. We are ready for the ruling.
So last time I requested for those authorities that were cited that that is neither of them, or neither side of the eye, that we sent it, but I was able to capture the same authorities. I think nowadays it's so easy to get those authorities. So then I'll proceed with the ruling. So Jayne Kihara, hearing after I referred to her as a suspect, was arraigned in court on this on the 18th day of July 2025 for to take plea on the offense of offensive conduct conducive to breach of peace, contra section 94, subsection 1 of the Penal Code. The particulars thereof has been successively set out that on the 8th day of July 2025 at Nairobi City, within Nairobi County, being in a public gathering, uttered words to read open court. I want to talk about Naivasha because I know those goods were transported in NYS bus in a place called Karangita. They were dropped there In town, they were brought in trucks in my mind. So all these people, nobody knew them. As I condole with the bereaved and also empathize with those whose properties were destructed, I want to tell President Ruto, this is not a war. You can win unless you want to destroy this country. It is about the youth. It's about young people who you went around promising heaven. And what you are doing now is digging deep so that they go under. It did not happen. In Naivasha, they killed one, 3 in critical condition. And as my colleagues have said, police are doing anything. They didn't try to arrest the goons. They're not doing anything. They didn't try to arrest the goons. You could see in the place goons working with them. So it is not anything that is going to end. We as Kenyans are prepared to prepare our country so that you cannot. We as Kenyans are prepared to prepare our country so that you cannot be drowned by one single person because you think you're so powerful, yet you have the power which we give you. You cannot use the same power to destroy us and destroy the country. End of quote. I'm quoting verbatim with intent to provoke breach of peace. So I take judicial notice that the suspect is a sitting and current MP, Member of Parliament representing Naivasha constituency. The suspect was represented by a battery of counsel who were led by Dr. Kalonzo Musyoka, Senior Counsel, Mr. Muturi, Mr. Kihara, Mr. Kiragu, Mr. Njiru, Mr. Weregi, Mr. Malemba, Mr. Nyambu, Mr. Wabugu Wagujohi, Mr. Mageto, et al. Quite a number. So the state, on the other hand, was represented by Ms. Nora, Mr. Witty JB, Ms. Sonia, and Mr. Milimani. So in its application, canvassed orally on the 18th day of July 2022, counsel for the suspect have vigorously opposed the suspect from taking plea. So that is the tenet and pretenses that this court is called upon to make a determination on. Dr. Musyoka, Senior Counsel, has urged that on the casual glance of the charge sheet, the suspect is charged with the offense of offensive conduct, contra section 94, subsection 1 of the Penal Code. Senior Counsel agreed that this is purely political persecution and that the alleged utterances falls within the constitutional realm and orbit of freedom of expression and press, and furthermore, the particular does not disclose any offense. He poignantly supplicated that other people or politicians have said worse statements, thereby ignoring selective and or discriminating prosecution. Senior Counsel was appalled by how the arrest was conducted in terms of the public resources used and the numerical force that was used against the backlog of the misdemeanor charges that now the accused has been arraigned. And therefore he espoused that the acts by the enforcement agency were all unconstitutional. On his part, Mr. Kihara, the speech and particulars of the offense as well do not disclose the ingredients and were unconstitutional. He submitted that being a member of Parliament, the suspect was a mouthpiece of our constituents and which she exercised by dint of Article 33 of the Constitution. Mr. Njiru guided this court on the enforceability of rights within the refraction of the constitutional imperative and the dictum vis-a-vis the statutory provisions and the doctrine of statutory decisis. He entreated that pursuant to Section 8.1 of the Magistrates Court Act, this court is clothed with the jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of, or threat to, a right or fundamental freedom in the Bill of Rights. We thus urge the court to invoke Article 33 of the Constitution in delineating whether the charge sheet borders on a threat to a right or violation of fundamental principles. Further, Learned Counsel Mr. Njiru, our most stringent argument is that the statutory provisions must be symmetrical and harmonious with the Constitution by dint of Section 7 of the 6th Schedule and Article 10 of the Constitution on national values and principle of governance. He thus avowed that this court has the jurisdiction in entertaining the instant application relating to the threat, the denial or violation of the suspect rights in the contextual review of Article 33 of the Constitution on the freedom of expression as juxtaposed with the Section 94(1) of the Penal Code. He buttressed further that the particulars do not disclose an offense for the suspect to comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights or fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic, and civilized society. Counsel also made reference to Article 19, 20, and 27 of the Constitution. On this part, Mr. Kihara extensively submitted on the composite of the offense that the suspect is facing, basically urging that the three ingredients to the offense has not been disclosed sufficiently. Concomitantly offending Article 52B of the Constitution. The learned counsel, Mr. Wambuku Wanjoy, iterated that the charges were not warranted since no clear offensive conduct had been identified, with the charge sheet being broad, vague, and ambiguous. He adjured that Section 94 of the Penal Code criminalizes conduct and not political opinion or opinions, with no nexus between the words alleged uttered with the breach of peace. Conversely, on behalf of the state, Mr. Whitty vehemently opposed and backed the application. He unerringly submitted that jurisdiction is everything, reverberating the old aphorism that a court of law down its tools in respect to or matter before it. He reverberated the old aphorism that a court of law down its tools in respect of the matter before it the moment it holds the opinion that is without jurisdiction. On the jurisdictional question of Section 881 of the Magistrates Court Act, learned counsel argued that under Section 828, Section 2 of the said Act, this court's jurisdiction is stemmed and hamstrung to rights under Article 25A and B of the Constitution. Corollary, excluding Article 10, 19, 20, 27, and 33 of the Constitution. He further argued that Section 94(1) of the Penal Code is in force and applicable in collocation to Section 7 of the 6th Schedule of the Constitution. He exhorted that, pursuant to the Article 2, sub-Article 2 of the Constitution, this court has no powers to legislate. Learned counsel further, Mr. Whitty, submitted that the relevant law governing the framing of charge sheets are found under Section 89, 134, 135, 136, and 137 of the Criminal Procedure Code. He argued that the charge sheet presented encapsulated the statement of offense and the particulars sufficient to be understood by the suspect. He enjoined that at this stage there is no need to prove any ingredient, each of the ingredients, since the court will be falling into a danger of conducting a mini trial. He beseeched that the ingredients ought to be established during the main trial. So he relied on two authorities, the Kuldeep Madan and another versus Director of Public Prosecution, as well as Hussein Khalid and 16 others. So distinction from the foregoing, two issues arises for determination, namely, jurisdiction to enforce the Bill of Rights by the magistrate courts. Secondly, the competence of the charge sheet. So on the question of jurisdiction, I'll start off with the Supreme Court case, Supreme Court of Kenya in application number 2 of 2011 involving Samuel Kamau Macharia versus KCB and others, 2012 EKLR, which the court held, and the court, a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court can only exercise jurisdiction as conferred by the Constitution or other written law. it cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. The court must operate within the constitutional limits. It cannot expand jurisdiction through judicial craft or innovation. End of quote. I'll also cite the famous case of owners of motor vessel, LNS versus Perfect Oil Kenya Limited, 1989, EKLR, where I'm sure all of us are familiar with this authority, so I'll not read it. So, as aptly stated by both parties, the jurisdiction of the magistrate court in dealing with the enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrates Court Act. The parameters, despite being clearly stated under Section 8, Subsection 2 of the Act, has also found fortification in the Supreme Court the decision of Hussein Halim, which I've quoted before, during above, where the apex court, whose decision is binding before this court, enunciated thus, and I quote, Parliament has granted to the magistrate courts powers to consider applications on alleged violation of the Bill of Rights, but has limited the power to only two rights under Article 25A and B. And that, according to the apex court, is that one is for the freedom from torture, cruel, inhuman, or degrading treatment or punishment, and also the freedom from slavery or servitude. I proceed to quote the apex court. This limitation is constitutional, as Parliament does not bar a person from bringing a case alleging violation of his rights, but only limits the forum where that cause can be done. They have cited this was captured by the High Court of Australia. I'm not going to those. You can have it once you have this ruling. So I'll share with you so you have a look at it. So, learn from the foregoing, it is crystal clear and need not be belabored further that this court can only enforce rights that fall within Article 25A and 25 subsection B, paragraph 3 of the Constitution. Therefore, on the elemental question of jurisdiction, I will down by 2. So I go to the second question for determination, and that is on the competence of the charge sheet. So the first port of call is on the mandate of the DPP. The office of the DPP is an independent constitutional office which is not subject to the control, direction, and influence of any other person. Under Article 157, Sub-Article 10, and Section 6 of the Act, the DPP shall not require the consent of any person or authority for the commencement of criminal proceedings, and the exercise of his powers or functions shall only be under the direction or control, or shall not be under the direction or control of any other person or authority. The independence of that office is, however, not absolute. Article 157, Sub-Article 11 requires that the holder of such office to have regard to public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process in exercising the powers conferred by the Constitution and the Act. So, based on the foregoing, it follows that the DPP can present charges within the confines of the law. The question for settlement now is whether, and which is paramount, is whether the charge sheet against the suspect is competent. So there are plethora of authorities on question of the competence of framing of charge sheet. So I'm not going to that. I'll go into Section 134 of the Criminal Procedure Code that states, and I quote, every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. End of quote. I'm not going to read Section 176. I've elaborated the provision of that Section 137. So, courts, as I've stated, has also considered what is essential in framing of a charge. In the often cited case, in the realm of framing of charges, the case of Sigilani versus Republic, 2004, 2 KLR, 480, I'll not cite that. What the court stated. So further, the Court of Appeal in Nyamai Musyoka versus Republic 2014 also expressed itself on the test whether charge sheet is fatally defective or incompetent. I will not cite it. So indubitably, therefore, a charge must therefore be clear and easy to understand. In as far as possible, the use of technical language in a charge sheet ought to be avoided. An accused person must be accorded an opportunity to understand what he or she is facing before court. I've cited the authority of Besman Katwenge Wafula versus DPP, that is petition number E045. So I'll go to the finality of the finding of the court. So in Doniment, I find that the requirements of a properly drafted charge sheet has been surmounted by the state. I find also on the face of the charge sheet, I'm of the conscientious view that the suspect will be able to fathom and adequately discern and be able to prepare for her defense. So the finding of this court is that I'll direct the suspect to take plea in respect to the charge sheet that has been presented before court.
Yes, Your Honor. We have listened to the hearing and we are well guided in regard to a number of issues that you have raised, and others will appreciate after we read the full text of the ruling. However, the defense, if you like, make an application to defer the taking of the plea today. Yes, to enable the defense team to get the views of the Constitutional Committee. On a number of issues, Your Honor, we need not to be emphasized, and as we argued last time, still with the suspect's team holding her guard, because he's entitled under the Bill of Rights not to say anything to the charges, to confirm whether she had statements or not. To make a reference so that the Constitutional Court is in a position to define the parameters of the constitutional privilege and the license of a member of Parliament when you are addressing your constituents' grave issues as a breakdown of law and order. There have been property destroyed. Lives have been lost. And I think a number of issues are very clear even from the ruling, that she's a member of Parliament, that is not in contention, that she takes a much wider license in terms of her freedom of expression at Article 33, as read together with the parliamentary statutes and the separation of power doctrine. have my colleagues here assist further, but the only thing I may mention, so that we ask you for a short time limit. We propose 14 days to be able to go to move the constitutional court. We have to appreciate that we are also going on vacation, but so we may not be sure whether we will get a date as fast as possible. The only thing I may mention is that we need to seal this license in terms of, even a judicial officer. Tomorrow could be arraigned on the basis of a judicial decision or a statement made in court. I do think that you think it's far-fetched, but we are living in very uncertain times. And I think it's good to mention that, so that we appreciate the doctrine of separation of powers and the license that goes with that office of a member of parliament in regards to our constituents' issues involving security.
Allow me to.
Thank you, my other friend is that.
I think what you can agree how many?
Yes.
Just for purposes of order.
Yes.
But if you have an ambassador going to Nairobi,
Yes.
even in a bit indicated the manner and the mode of arrest,
Yes.
castigated the agency for the way the arrest was done.
Yes.
So it's holistic. On the question of, and I've explained it to the Supreme Court, I've cited that case of Ali.
Yes.
On Section 33, in as much as I would be really wanting or urging to make such determination, but my hands are tied.
Yes,
We are appreciating that.
Yes, you actually want to address you why your
Yeah,
hands
but-
are not tied. And at the fullness of time, you grant us the stay. And the the High Court will be able to set that record clear. I am of the convinced opinion that your hands are not tied and that Section 8 does not limit you. And that is why you honor the justification for the stay. But let my learned friends add
So
first.
how many of you will like me?
We are only the four of us. So if Mr. Muriu goes first, then my learned friend goes, then I'll sum up.
Thank you. With the utmost respect, Your Honor, we are dealing with an extremely fundamental issue touching on Article 33, the freedom of speech. Going by your dissection, both under the Constitution and the civil procedure, this matter is a purely a Bill of Rights issue. And therefore, it requires a considered interpretation on what constitutes to a crime by a citizen of this republic, and also what constitutes a crime by an elected member of parliament, or an elected member to represent people in various legislative bodies. Your Honor, this is informed by the fact that the role of an elected member is, number one, representation. Number two is legislation. And number three, Your Honor, is oversight. And therefore, when a member of parliament makes a statement on the state of affairs in his constituency, and then that statement is criminalized, Your Honor, I would say without any hesitation that if that's the case, we no longer have a country. And therefore, that's what I urge kindly to allow us to have that interpretation in the International Court, and we defer the taking of the plea of the accused. Thank you, Your Honor.
Your Honor, with your kind permission, my name is Mansa. Your Honor, we are pleading with the court that you give us a stay for their ruling for 14 days. And Your Honor, at the same time, stay the taking a plea so that a very important constitutional matter can be explored, probably in a manner that has never been explored before. Your Honor, the reason is that this sort of charges have become very many recently, and the court needs to state its position squarely, which has not been done before. Otherwise, these courts are going to be flooded with similar cases, overload the court system unnecessarily, and even spend the public money wrongly on the part of prosecution and on the part of judiciary, pursuing cases which will end up in acquittal. And that's why we are pleading with you that you take your ruling, and you also suspend the charges so that we may squarely now go to the court fully entitled to interpret those sections, and Your Honor, justice is important for the country. I thank you.
I fully associate myself with the submissions made by my learned seniors and give you the justification why you ought to grant us an order of stay. This order of stay we are seeking, Your Honor, is akin to the orders granted by the Supreme Court of Appeal, the famous Rule 52B. And therefore, Your Honor, what we need to satisfy you with is whether or not there is a justification for that stay. It has been urged before Your Honor that the chargeship borders between violation of a fundamental rights. Therefore, the question to answer is whether or not, if that charge is read and plea taken by the suspect, whether it will amount at the fullness of time to a violation. Whilst answering that test, Your Honor, we shall be answering the question of rendering the intended constitutional petition nugatory. If she takes plea and then we move tomorrow to the High Court or today to the High Court, will it be an academic exercise? Will it amount to an academic exercise? That is a test that will the court ought to apply. Number two, Your Honor, is a test that, granted the magnitude of the petition that we intend to file and the consequences that will befall the accused person if she were to be found to be guilty, would eventually culminate to a fine of 5,000 or 6 months imprisonment. That is to say, therefore, the violation may be much more surmounting than the consequences that will befall her. The other test is whether there shall be any person who shall suffer prejudice. And the state being the complainant, and in the absence of a private citizen who would fall in the category of a victim, the balance tilts in our favor. That there is no natural person saying that Honorable Jayne Kihara has wronged me in this way, and therefore the delay will occasion injustice to that particular person. Because this is an alleged offense against public order. The other justification, Your Honor, is that we need the High Court to expound on Section 8. And this is a justification, Your Honor, that Section 8 cannot limit you to the only rights under Article 25, A and B. Because A and B speaks about torture and being subjected to slavery and servitude. Yet today, or even when we appear before you, you exercised a right under Article 49. Article 49 is not what is encompassed under Section 8. Therefore, to say that Section 8 is constitutional would therefore mean that you today you not even have the ability of exercising the rights under Article 49. Because Article 49 is not covered under Section 8. It therefore means that all these courts have been acting unconstitutionally. Number two, Your Honor, while Article 25 speaks about the non-derogable rights, among them Article 50, the fair hearing is not encompassed, is not protected under Section 8. Does it therefore mean that this court will not, or any other magistrate court, cannot exercise that right under Article 50? Because Section 8 limits. The other justification, Your Honor, is that this court is enjoined by Article 10 to enforce the Bill of Rights. Article 10, which binds all state organs, state actors, state, whenever any of them is interpreting the law or applying the law, is not covered under Section 8. So the question will be put into the High Court is, can Article 10 give and Section 8 take away? So those are very fundamental issues that will settle the law on the ability of the Magistrates Court to enforce the Bill of Rights. Because Article 10, Your Honor, provides in a blanket way that you must enforce a Bill of Rights. And when enforcing them is protect them from denial, from infringement, from violation, or even from a threat. And therefore, to protect that foreseeable threat, the application for stay is justifiable. And it's not just justifiable, it's justicious. And Section 8, Your Honor, does not bar you from applying the doctrine of proportionality while granting this stay, insofar as the rights that we are seeking to protect are in issue. So, Your Honor, there is all reason to justify that one, the accused persons before you, or the suspect before you, is a state officer. What she's alleged to have violated relates to her constituency. There cannot be representation without speaking. That is, there cannot be representation without the right of self-expression or freedom of expression. The state says we have violated it. How then will representation ensue? So, by the stroke of the pen, Your Honor, it can, or by the action of the ODPP exercising their power under Article 157, can actually amount to a limitation of a right, and that is what you want to go and argue in the High Court. And we are not offended by your findings. We are offended by the legislation. That the legislation is purportedly limiting you to protect a right. 14 days, Your Honor, is not so much to ask. Honorable Jayne Kihara will still be within the jurisdiction of this court. She will be available and she will be subject to you. So we can have a mention in 14 days to confirm the outcome of our proposed petition. If this, Your Honor, is not going to be done, you'll see a litany of members of parliament appearing before you. Even myself, I may appear you before you, especially when I say one term. I'll be next. Especially when I propose a doctrine of one term, which you propose out there. So, you know, or the member of parliament for Natanga. So, you know, we urge you to grant us this stay, subject our arguments to those three tests: who suffers prejudice, whether the proceedings will be rendered nugatory, whether they will amount to academic exercise, and whether it is justicious for us to move to the High Court and check the possibility of Article 10 giving and Section 8 of the Rights of checking. Thank you.
You know, we might be saying all that and the state is conceding.
We will come the concession.
I have a few comments. You know, as you have rightly stated in your ruling, the only issue for consideration here would be whether the charge sheet that we presented before you was proper under Section 134 of the CPC, whether it discloses a known or existing offense, and whether the suspect hearing will be able to defend herself or rather understand the charge well enough to put in a defense. And those questions have been answered in the affirmative by your ruling. Yona has also distinguished what pertains to freedom of expression under Article 33 and whether this court can deal with issues pertaining to limitation of some rights under the Bill of Rights, and as rightly stated by the court, and the authority that the court alluded to, the only violations that this court can entertain in line with Section 8 of the Magistrates Court Act are the ones under Article 25A and B. At this point in time, plea taking may not bar the defense from moving to the High Court for a constitutional interpretation. Decisions of any court higher than this one are binding on this court. I have not heard them indicating to us the prejudice that the suspect will suffer once she takes plea. The office of the DPP will also be bound, is also an office that is bound by decisions of the higher courts. When we were here last before you, the argument by the defense was that the charge sheet presented offended sections of the law. That the court has dealt with. So, Your Honor, it is our submission that nothing bars the suspect from taking plea at this point. They can move to the High Court for interpretation of the section of the articles that they indicate. Once the High Court pronounces itself, then this court will comply with those orders. So at this point in time, the suspect is before court. The court has indicated that the charge sheet is proper. So we oppose the application for deferment of plea. That is all.
I'll ask the regulator report on the issue that you are raised of prejudice.
You know, I take it that the prosecution has not controverted our arguments. Other than subjecting a question to us that we have not indicated the prejudice she suffers. That is on record. She has not urged you to find that she will suffer any prejudice whatsoever. And to the best of my knowledge, is that the office of the ODPP is an independent office. They are bound by the decision of the Supreme Court or Superior Court. Yes, but not their decision to charge, because that is independent under Article 157. What we are asking, Your Honor, is within the provision of the Constitution, Article 165, Clause 3D, that the High Court may have the opportunity of determining whether anything said to be done has been done in accordance with the Constitution. And therefore, that's how we shall be invoking the jurisdiction of the High Court. And the same can even be exercised if we were to invoke the supervisory jurisdiction. But we are not asking the High Court to supervise you because you've not made any error. We're not asking the High Court to supervise you. We're asking the opportunity to test whether anything said to be done by the ODPP has been done constitutionally. That is not invoking the supervisory jurisdiction. And as such, our argument, Your Honor, remains uncontroverted. We are most obliged.
So if I can get you right, you say this, if I allow this, it will be a threat to MP.
I think I'll invite my learned friend who is a political animal to answer that.
Honorable members, yeah?
Yeah, this is very serious, and because this is what you call guarding. Because, as I said in my submission, the role of Parliament is to represent an oversight. You don't represent an oversight in silence. You expound the wishes and aspirations of the people who have voted for you. In fact, it goes to the group norm of the fact that why did you even vote me in the first place if you got me? And that's why we are saying, Your Honor, it is very important that we be allowed to go and make that interpretation. Because what will happen eventually is that if me as a member of Parliament for Gatang constituency, I'm gagged, you as a magistrate, you're also going to be gagged because of making certain decisions. And therefore, this freedom is not for members of Parliament. This freedom is not for the members of the press. This freedom is not for, is for every citizen as guaranteed by Article 3. And therefore, it's very fundamental that we get that opportunity for the good of this country. Thank you.
So if I've heard your arguments and submissions. So first of all, I'll share with you the ruling on the question of controversy and the other issues that were shared. And then I'll request you to come on Tuesday next week. So in the meantime, I'll extend the bond because I got the But one thing I want to request, you know, as a court is a hallowed temple of justice.
Yes, sir.
And we would want it to be, we are political.
Yes.
As a court.
That's correct. That's why you never said one time.
Yes. You just said that. So substantive, and I was told, and I take judicial notice, I was told that there were chance of that what you just said there. So I just respectfully,
We must oblige.
with all humility, I think, so that we can maintain the dignity
That's correct.
of this hallowed temple of justice.
That's correct.
Let's not utter such words.
We'll advise my
Once you're out there at the gate, you can shout the top of your voice. But once we're within here, let's just, you can sing the national anthem.
We are
told last time you guys, which is quite patriotic.
Yeah.
But some of those utterances or chants, let's just keep it off.
We are grateful and apologize.
Because we want to maintain the dignity of the court.
We are most obliged.
Because we're purely political, yeah?
We are most obliged, yeah.
Because we have to speak for each and everyone.
Absolutely.
Whether you're a member of parliament, whether you're a normal citizen, yeah? They're all people before the law. So let's just respect that. Let's not, once I leave, I'm told that, like last time. So I'll have extended our bond terms to Tuesday, the 5th of August.
If kindly allow us to convey our apology, that will not happen again. We shall allow them to sing the national anthem, but that will not happen again.
Yes, we are trying to we appreciate and the extension. Can we request you to give us Wednesday instead of Tuesday? There are a number of related cases.
So can we agree on the sign?
Okay.
Sorry, I am corrected by my land friend. Well, after he's supposed to be the member of parliament. Like 7. Yes, we are requesting for 7.
At 11, Your Honor.
7 at 11. So you'll be exact at 11.
We are most obliged.
So I thank you. Also for you understanding it, I was a bit late. I sincere apology.
It's okay.
But in the evening you get the ruling.
We'll get the ruling by today.
Yes.
By today, so that we can also get back on the other exercise.
Indeed. So I still have the matter, so I'll excuse you so that you don't want to stand.
Much obliged.
Thank you.
The main party has seen another comment to say, excuse the politicians.
Wish you all a big afternoon.
Please maintain silence, the court is still on.
Karibisha hiyo ya K24 nikuonyeshe.
Kuja.
Bado. Speak Wednesday. Just a minute.
Asante sana. Siku ya leo tumekuja hapa kotini kama mawakili wa Mheshimiwa Jayne Kihara, mbunge wa Naivasha, kuhudhuria maamuzi ya koti kulingana na vile koti iliamua wiki ambayo ilipita, kwa sababu wakati tulikuja kotini tuliambia koti ya kwamba hakuna hatia yoyote ambayo ilitolewa na ile charge sheet ilipatikana ama ililetwa kotini, na kwa sababu yale mambo ambayo Mheshimiwa Jayne Kihara alikuwa amesema serikali imeleta majambazi Naivasha wakuja waangamize biashara za Naivasha, na hawa watu hawajulikani, na mtu mmoja alikufa na wengine wako hospitali. Kazi ya mbunge mimi na oversight watu ambao wanipatia kura, na ndio hapa siku ya leo tulikuwa tunaambia jaji ya kwamba hatuwezi enda katika plea kwa kufanya kazi ambayo tumeshapatiwa na wananchi, na hii jambo pia ya ku-weaponize speech ya wabunge, speech ya Wakenya, hiyo inaadhiri article 33 ya katiba yetu ambayo inaongea habari ya freedom of speech. Na nimesema pia kotini ya kwamba hata wacha ukiongea kwa bar, ukiongea kwa hoteli, ukiongea kwa shamba, unashikwa na hata kotini, nobody is safe in this country. Na kwa hivyo nataka kushukuru koti siku ya leo imetupatia nafasi twende High Court ili koti yako juu iamue kama mtu kama mwananchi wa Kenya akiongea mambo ambayo yanafanyika katika nchi hii, kama mbunge ama mtu ambaye amechaguliwa na wananchi akiongea mambo ambayo inaadhiri watu wake, kuna hatia yoyote. Na kwa hivyo tumekataa katakata mambo ya weaponize and criminalize politics. Na kwa hivyo, kwa sababu kama Mheshimiwa Jayne Kihara akichukua polisi siku ya leo, ni kusema kila mtu kesho, hata sisi ambao tumesimama hapa, hata nyinyi watu wa media, kesho utajikuta kotini, kwa sababu tumefungua floodgate ya serikali iwe inasema mtu yote ambayo asemi kasongo 2 term, unasema 1 term, yote anapata akiwa kotini. Kwa hivyo tumeshukuru sana kwa hiyo koti. Tutaenda High Court for interpretation for the good of this country and the liberty and freedom of speech ya nchi yetu. Asante. Kwa hivyo tutapatia nafasi maybe Mheshimiwa Maanzo pia ambao ni wakili pia tulikuwa naye pale pia aongee mawili matatu.
I would like to say that what Honorable Jayne Kihara did was to report something which is factual, was to exercise a duty to represent. She was talking on behalf of the people of Naivasha. She was also a witness, an eyewitness of seeing goons transported in a vehicle belonging to the government and particularly NYS. And therefore, by stating a fact, you cannot be declared a criminal. And we want to say that if every single thing said in this country is going to be criminal, I have told the courts that we are going to have so many cases that there will be not enough courts to try them, and we cannot open such gates. And therefore, we are grateful to the court. It has sent us to the High Court, where this issue of freedom of speech, vis-a-vis whether a magistrate can deal with human rights to a certain extent, is interpreted so that we can settle it, and that there is freedom of speech in this country, which is being done by the current government, and especially to those who have been given a job by Kenyans to represent them. And any other Kenyan is free to speak, and is free to witness, and is free to state what they have seen the government doing. There's no crime committed when you do that. And therefore, we want to say, let the country slow down, let every citizen not be scared, not be threatened by the bullets which are being shot recently, even to cars of members of parliament. We have taken these matters to IPOA, and we want justice to prevail in this country and the Constitution of Kenya to be followed. And that's why we are going to the High Court, to make sure these issues are determined and settled once and for all. That's that.
Asanteni sana. Ile kitu naweza sema ni kusema hii ni political persecution, kwa sababu mimi nimechaguliwa na watu wa Naivasha. Mimi ndio macho yao, mimi ndio masikio yao, na pia wananiambia ile inafanyika. They are able to reach me na phone call any one time. I have not heard who I incited, because I remember when I said what I just heard now. I was talking to you people. It was a pressure. So I don't know who I incited. So I thank my lawyers. Thank you very much, team. Aluta continua. Tutaendelea kwa sababu mimi nimekuwa pale. This shooting of Sunday, I was still in that convoy. ile vita ilikuwa Mwiki, I was still there. Ile ilikuwa Shamata nilikuwa. So kama hiyo ndio shida, then like my colleagues say, tutaendelea namna hiyo. But we have to talk what is happening. We have to tell Kenyans. I have been elected by Naivasha people to represent them. I cannot talk to them in sign language so that I don't talk. It has to be understood. So I'm grateful to these lawyers. And I'll follow them. I'm happy at the argument I had. I was reading the Constitution as they went on the process. So ni kusema tutaendelea tu. Tutaendelea, Mungu mbele. Wa Kenya, let us pray for this country, but we also have to tell it as it is. Ile mambo inafanyika mbaya iendelee kufanyika, kinyamaza, then we will have failed in our duty.
Thank you so much, members of the court state. We are here in solidarity with our colleague Jayne Kihara for a political persecution. We are asking the court to be magnanimous now and to respect the rule of law. Kwa sababu we are about to set a very bad precedent. Mahali mtu atakuwa anaongea anakuwa persecuted politically. You know, the law will succeed William Ruto. He's here for the next 2 years only. So basically yeye kazile sheria yenye itakuja kutumiza hata baadaye. So we condemn these acts and we not be cowed, hatutatishwa. Tumeangalia Gen Z wakiongea wanakuwa abducted, wanauawa. Saizi wabunge wakiongea wanaanza kutishwa na makoti. Ukiangalia freedom hata movement saizi umeona vitu vimekuwa kihappen to our team, the DCP team. Kila mahali watu wakienda wanapigana tear gas. Unaona hadi polisi anashika mawe, hadi risasi, wengine wanajaribu attend on the lives of people. We will not allow these keeps by William Ruto. Ajue ni kuenda anaenda. Ajue ni kuenda anaenda anatoka kwa hii uongozi. Na tutakubali nchi yetu iharibiwa na mtu mmoja kwa sababu ya interest zake zenye hata hatuzielewi. Na sisi tunasema we will continue soldiering on. Na kama atatuua, kama atatufunga, wacha tufunge sisi wote, si ndio? Wacha tufunge sisi wote. Hata tukiwa wengi kwa jela tutakuwa tumeanzisha sako huko ndani. Itakuwa tu mabesti tumekaa ndani. We are not afraid of him, but pia ache kutumia justice system hivyo. Utafanya majaji wengine wa make wrong decisions zenye zitawakost maisha na maisha, na pia hata iharibu hii nchi sana, lakini hatuwapatie chance. We'll continue speaking out and we are the people of Kenya. We're bold enough that we speak out more and more mpaka tuondoe hili regime. Thank you so much and may God bless you.
Basi na mimi kama naibu mwenyekiti wa DCP nimekuja hapa kwa sababu tunajua mbunge Jayne Kihara anadhulumiwa sababu anaonekana anaegemea upande wa DCP. Lakini nataka kuambia Kasongo ya kwamba you can have power, but power is transit. Usifikirie utakuwa na haya mamlaka forever. We are going to stand with our people. Nakumbuka nyinyi watu wa Ford Estate, niliona mlituonyesha wale goons walikuwa wanapitia nje ya ofisi ya Sakaja wakisema asante, tumefanya kazi yetu. Kama sasa wataendelea na hii kesi, inaonekana hata nyinyi mtapelekwa koti. Kwa hivyo kuonekana askari kuonekana na goons na wewe kusema wako na goons, unashikwa unapelekwa kotini. Kwa hivyo letu ni kuuliza rais, tafadhali wachana na watu wa opposition. Wacha tufanye siasa yetu kwa hali ya amani. Wacha kutuma askari kama ulivyotuma kule Murang'a wakiwa na vijana. Tuko na picha hapa, tuko na video. Askari wako na uniform, vijana wako na vijiti, wao wanapiga risasi juu, wakapiga gari zetu marisasi na vijana wanachapa watu, na askari wako hapo na hawezi kuwakamata. Tukisema hiyo ni mbaya, tunaletwa kotini. Sisi tumekataa.
A very good afternoon. Tunataka kusema tumeshangaa kwa sababu the judge hata yeye akisoma hiyo charge sheet, well, I'm sure even on layman language and thinking tumekosa kuelewa what is Honorable Jayne Kihara charge, kwa sababu kisemekana ati amesema hivi Naivasha na yeye ni representative wa watu wa Naivasha, it beats all the logic. Lakini nataka kumweleza ama kumkumbusha Mheshimiwa Ruto wakati wa campaign alisema hata waifanya kama haya. Alikuwa anasema tuondoe ile serikali na tusikubali serikali ambayo Uhuru Kenyatta anataka kuleta, kwa sababu yeye akichukua mamlaka na akuwe rais wa Kenya analeta mwamko mpya na prosecution, extrajudicial killing, yale mambo yote alisema ndio sasa anafanya. Alisema hata tumia justice system kuwida watu kisiasa, hata tumia judicial system kuwida watu kisiasa. Nataka tu kumweleza Mheshimiwa Ruto, ikiwa your manifesto for heaven's sake was just make you the president, basi simama kama mwanaume, sema hiyo ilikuwa panyarut, na kwa sababu ilifanyika tuambie ni hivyo, but leave us at status quo. Kama ni mambo ya masomo wachana nayo kama imekushinda, kama ni afya wachana nayo, kama ni kutumia polisi wachana nao, kuwa tu rais kwa hiyo miaka 2 imebaki. Come 2027 uende sugoi pole pole. Tunasimama na Mheshimiwa Jayne Kihara, tunasimama na watu wa media, tunasimama na Gen Z na Wakenya wote, na Wakenya wasimame na waseme mabaya ni mabaya bila uoga.
Asanteni sana. Tuko hapa kotini na mimi nataka nishukuru mama kwa sababu yeye ndio sauti pale Naivasha, na mimi kama mtu wa one time tutasisitiza na hatutatishwa, kwa sababu Biblia inasema kuzaliwa ni bahati, kukufa ni lazima. Sisi wote ni marehemu watarajiwa, ni wenye hatujajua siku. So mimi nimesikia pale wakisema ya kwamba ofisi ya DPP ni independent. Mimi sijaelewa sheria ya Kenya inatumika namna gani, na mimi nataka niseme ofisi ya DPP sio independent, inasukumwa na rais ambaye ako juu. Na mimi nataka niambie Rais Ruto, saa hii unaweza kuwa kwa power uongee venye unataka, but venye unatufanyia huwezi jua rais mwenye ataingia atakufanyia namna gani. Jua ya kwamba ukiwa kwa power siku moja utaachilia hiyo power, na venye unatufanya hata pia sisi tit for tat, na watu wako pia wasilalamike sana, kwa sababu wewe mwenyewe ulikuwa unasema hautatumia mapolisi kuangamiza wanasiasa. Wanasiasa watakuwa wanajieleza. Mimi leo hii nashindwa kwa hii rejimu ya Ruto, wanasiasa ndio wamejaa kotini na makesi mingi. Mimi hata Nuru Kanga sina panga kwangu, niko na kesi 6 kotini na hazijatolewa. Baada nasisitiza mimi ni msupport ndiye atoe. Unaona wenye umefanya kidole hivi tu ni one time, na sitarudi nyuma, na sikuogopi na kuheshimu, lakini sikuogopi. So tutasukumana tu. Sauti ya Naivasha, welcome to speak something.
Thank you very much, the members of for the state for coming to cover us up. I want to thank also the lawyers who have been with our honorable member, Mheshimiwa Jayne Kihara. We at Naivasha, this is what we want to say, that for Mheshimiwa to take our issues forward, she must speak. And if speaking will make her be brought to court, I think she will be brought to court 10,000 times, because she speaks on our behalf, and we are the people who send her to speak on our behalf. So today we want to say that the court is clearing that there are no charges for her. The charge sheet does not read anything, and we have been referred somewhere else so that we can go and find, they can go and verify and find justice. And we are hoping in the next level we're also going to find justice, because there's no way you can be in Bunge and not talk about your people. So we at Naivasha are pushing on, and we are supporting our Mheshimiwa, and anytime we see something happening, we shall be calling her and telling her, so that she can take care of us and she can forward the same to speak on our behalf. Thank you very much.